Thank you very much. That will bring the hearing to its conclusion. Let me thank the three witnesses for being here today. The hearing record will remain open for 1 week for any statements to be submitted to the record. Questions for the record may very well come to you from senators. They are due by 5 p.m. on Tuesday, July 26. If you could respond to them expeditiously, that would be very helpful to the committee. I do want to conclude by saying that what we're trying to craft here is something that is quite narrow and I believe consistent with the due process concerns of the United States Constitution. First, it would be in scope limited to where a presidential declaration of a national security imperative has been made. Second, it would proceed through an initial proceeding in which the government would be obliged to get a warrant to proceed against whatever the asset is, the painting, the aircraft, the yacht, the mansion, the penthouse, whatever. At that point, administrative procedures are pursued to go through the process that Mr. Adams described of holding and managing and preparing for sale or I guess condemnation is a fair enough word, the asset. But there will also be a proceeding in which that can be challenged. And that proceeding is also in court. And the claimant to the asset, who thinks it's being improperly or unfairly seized, has every right to show up at that point and make their case. What's important to me is that the onus be put on them to come forward and make their case, because that cuts through all this maneuver and screening that Mr. Smith described, which can be ongoing through the entire process while it's happening, and requires the actual owner to come forward. That's really not asking all that much. They will have actual notice if it's a $500 million yacht, for instance, that something of theirs is now no longer at their disposal. So I think it's pretty fair to assume that they will have, in fact, notice, and then they have to come forward. And the additional value of them having to come forward in court, in addition to having to present themselves, is that they now have to testify truthfully and subject themselves to discovery related to the question of ownership and the legitimacy of ownership of the asset. And that's important because otherwise the government is condemned and handicapped and hamstrung by having to play the game of eternal chase through all the screens and schemes and international hidey holes that they use, and with a pretty adept group of lawyers on the other side maneuvering those screens and hidey holes and shell corporations in a real ongoing basis. For me, the operation that the Department of Justice ran against the cyber botnets provides a pretty good exemplar of where we're trying to go, because you could never go find who was running that botnet. Wasn't going to happen, but it is there. And if you proceed in rem against it and give notice to the world, come on in if this is your botnet, otherwise we're proceeding against you, I believe that is consistent with due process, and we're going to try to proceed along those lines. We're grateful for all of your testimony and look forward to your continuing to advise us as we continue to proceed to land this bipartisan bill and provide the resources that we can from malefactors in the Russian oligarch world to the people of Ukraine who are suffering so grievously. With that, the hearing is concluded. Thank you all.